want to talk to you for a second about arbitration. In most superior courts in Washington State, we have something called mandatory arbitration. Basically, what that means is that we can compel the defense, the other side, to go to arbitration, which is an informal version of a trial, as long as we stipulate or agree that the damages that we're going to ask for, in other words, the amount of money that we're going to ask for, is $50,000 or less. Now, there are pluses and minuses to going forward with the mandatory arbitration process. The first plus is that it gives both sides a reality check. A neutral third-party attorney hears all the evidence and arguments presented by both lawyers, just as though it were a trial, and then they make a decision, just like a judge and a jury would, where they say, I either agree with the plaintiff or I agree with the defendant, and if I agree with the plaintiff, then I award them this much money, again, up to $50,000. A lot of times that arbitration award will be a reality check for one side or another so that they realize that their case has some issues that maybe they didn't know their case had. Now, the second thing about an arbitration is that it can be appealed by either party. So if either party does not like the arbitration award, that party can request what's called a trial de novo, which basically means the case gets pulled out of arbitration, put back into the superior court schedule, and starts marching towards trial. Now, the good thing about that is the party who appeals the arbitration award has to improve their position at trial. And if they fail to improve their position at trial, then they have to pay the other side's attorney's fees and costs from the time of the appeal forward. Now, what does that mean in English? That means that if we go to arbitration on a case and get an arbitration award of, let's say, $20,000, and the defense doesn't like it, and so they appeal the award, we then go all the way through trial, and we wind up with the same award, $20,000 or higher from a jury, then the defense, in addition to paying that award, would have to pay the hourly attorney's fees from the time of the appeal all the way through trial, which could be $20,000, $30,000, $40,000, $50,000 even. So there's a major disincentive for someone to appeal a reasonable arbitration award, and that's one reason why the mandatory arbitration system works.